Afternoon, everybody. It's AJ back. 15:23 for the record. It is Wednesday, September the 24th, 2025. So normally I would have a court appearance tomorrow on the 25th of September 2025. A court date that was set back in December 2024, December the 12th day, so 2024. This was when I was released before Justice of the Peace at 161 Alien Street, Ottawa Courthouse. And basically I was released without any bail condition, any surety, what have you. Basically kosher, nothing wrong. I had basically just waiting for my court date, right? Tomorrow, anxiously. It's been almost over a year now since the incident took place back in August 24th, 2024. And this is the subject of the lawsuit, where basically the defendant, party B, basically, so it's party A, AJ, versus basically the subject of my ex-wife, and that's the application before the Supreme Court of Canada. Because last I checked, we had amicable divorce agreement before the Superior Court of Justice in Quebec, and my ex-wife has unilaterally, without my consent, breached that amicable divorce agreement. So by retaining and agreeing to retain the unsolicited, illicit legal advice by no other than the Western Quebec School Board, as this matter involves my child daughter, my sole child daughter, as I did not consent for my child daughter to undergo therapy sessions as advised on the recommendation and requisition of no other than the school principal at South Hall Elementary School, Monsieur Eric Tremblay, and the daycare technician in question, Ms. Plain, as well as the Western Quebec School Board agent by the name of Hannah Altimus. So I had, obviously, as a concerned father, I had revoked my consent for my child after day school program, because my child is almost 10 years of age and does not require these therapy sessions. First of all, I was trying to seek information as to the nature of these therapy sessions, and at the end of the day, as a trusted guardian father, natural father, and biological father that is to my sole child daughter, I did not feel the need that or had enough information or time to decide. And they were so anxious to start on the December the 4th, the therapy sessions, right? Of course, I had revoked my consent on the 26th of November 2024, and basically I had been separated from my child at the after day school program, and I simply demanded that I speak with the administration of the school board, where my daughter she attends, with the parties in question, that is my ex-wife and the school principal and the daycare technician and the basically agent, WQSB agent, to basically go over the concerns that I have as a father, natural father, and again, amicable divorce agreement before the Superior Court of Justice in Quebec. So 27th of November, I received an email later in the day, and the following day, on the 28th, that is on Thursday, if I recall correctly, basically I had gone and I have a record, 28th of December, and 28th of November 2024, and I had gone basically to demand that I see my daughter, following basically unjust and unwarranted email. All I wanted is to make sure that we have a clear understanding of the roles and responsibility, and I had been pledging with my ex-wife before the matter had escalated to unnecessary length, where basically now she did not consent to going back to the avocado, right? So the family lawyer that she had sought and asked that we go through amicable divorce agreement, which I agreed to, and we've gone through the motion 1, 2, 3 sessions. You have the provisional agreement, and it was certified, and amicable divorce. We're happily met, and we happily kind of left, and she initiated the divorce application. We had been married in church before Father Jorge, and the second church, that is, because the first one denied our Holy Communion, right, or union. So now, 14 years later of committed relationship, I cannot force anyone to be with me and agree with my point of views, but that's your life and my life. So we have a common child in custody that we both need to honor and respect the agreement that we had arrived to. So you can go about your life and I can go about my life. It's that simple. Whereas now I'm basically have been robbed away of my natural and father parental right to my daughter, and as well as a child has been deprived the natural bond union between her family as well as her father's extended family. So my nephew, my cousin, and my daughter had been an integral part in the family, both sides, my in-laws and my own family, or my ex-in-laws at this point. So I had been always invited for communal celebration, be it in the Christian or the Muslim faith. My ex-wife was born Latina Catholic, and I was born indigenous Palestinian born refugee, so Muslim. So came to Canada, minor. I celebrated my 15th birthday here in Canada, Ottawa, larger south basically, and I had gone through life motion, ESL, English as a second language, going on to seeking higher education, as I have graduated with honors. I went on to basically continue and complete my studies in basically aerospace electronics, system design engineering, right here at Carleton University, Ravens, right? I was class 2009, and basically I had jump started my career back in 2006 and gone through the life motion experience, navigating the basically my career journey and industry landscape, different market and application domains across different industries. So this is not about my obviously resume. I'm an entrepreneur. I had made the conscious and free will decision to leave the corporate world and leave behind a respectable, prestigious six-figure salary, right? And we have the record. So I had basically left to pursue my own business and as a small business owner in the space of green energy and so-called renewable solar and wind. I thought, well, this would be a good mix between physical work as well as technical work. My father is a master electrician, Red Seal, so I figured between myself and my father and two more maybe crew members, we can have a very competing family business. And now with electrification and net zero and the whole shenanigan, well, there's a prime reason for new and renewable ways to generate electricity. So this is where basically the matter gets more complicated as I get banned from LinkedIn from 0 views to 300,000 views over the span of like 5 months. I had started posting in June 2023. The previous year I had been helping a local small business friend and owner right here in Ottawa, south basically, right? And to close on sales for solar systems. I happen to be well versed with the technology, and I have a knack to speaking and explaining technical information, and I'm a subject matter expert, so I would be trusted by the likes of homeowners and business owners alike to do the energy audits and propose customizable and custom solar solution or energy solution. 2023, I basically ventured off on my own under 613 Solar. So I have been posting on LinkedIn for since really June 2023, but it's really not until December 2023 roughly where I start seeing uptick. And previously I had just been posting on solar technology and in general, and different technical terms. And I had managed to develop an app and front end, back end, the whole shenanigan, where basically you would type an address and it's like a Google map, and you would get the answers you need, rather than waiting through weeks and months before you get basic information from different solar contractors or companies. So you need the minimum solar system size based on your location and energy profile, and how much does it cost on average based on the market research, and payback. And it's, again, I've done the work and I have a GitHub. It's there. Smart Nancy Victor Martinez, NVM. And so basically I have a life ahead of me. I just turned 40 legally. I just turned 40 last July 27, 1985. And I am claiming the name of no other than the subject of the accused, with the name and, a trust account that is held in my social insurance number, right? So all the information is below. So this is kind of my VZO, right? Visual, oath and testimony, so to speak, oral testimony as for the application to appear before the Supreme Court of Canada, because you have to submit an application of appeal before you can be heard, which under the criminal charges, and cross province, basically inter-province jurisdiction. Well, we have the Supreme Court of Canada as a final recourse, because time and time again I have been going through the court motion and following the judiciary process, if you will, the due process of the law, to no avail. So now I must assert my constitutional right and my unalienable, unmutable, fundamental, natural rights and freedom as safeguarded by the Constitution. So this is an application with a safeguard measures, right? Declare of the emergency, right? And as well as a peaceful declaration. I'd be more than happy to go through the court proceeding as a self-represented, right? IAJ, right? I have power of attorney. I'm the sole chief executive officer, right? And director of the legal estate registered in my first name, capital, last name, right? And we have all the court file numbers, so to speak, and the transcript that can be basically retrieved before a public inquiry, as well, to serve fundamental justice. And that's basically where I am, and I'll keep this video. Now we're almost 13 minutes, so I think I've covered what I need to cover for my application before the Supreme Court of Canada, and I'll go through the list. Normally you need the application, who is the parties, party A, AJ versus party B, in this case my ex-wife, and the information provided below to basically a copy of the latest and most recent court orders that are, I believe, unlawful. So now I'm demanding a court injunction against any civil and criminal charges and court order that has been issued by lower courts. And I do also want to bring a motion to combine my court cases in Quebec, Ontario, Alberta, as well as somehow they have it from my house in Belleville. So I've at least 4 pending, right, with the first one in Quebec being acquitted, and as the court has been cancelled on the 10th day of September 2024. So again, this is going through the court motion. I have my facts, my evidence, and the body, right? Undue bodily harm, and basically, that's what happens, right? You get to be, tasered, right? So I almost lost my life. And again, I have the evidence, I have the recording, and the recollection of all the event that has transpired from the 17th of November 2023 all the way to present day and moment as we speak. So I look forward to presenting my case before the Supreme Court of Canada, public trial with a jury. And for that reason, I'm seeking a court injunction. And again, remedies will be sought, but first is truth and reconciliation. There cannot be any reconciliation before the truth is heard and fundamental justice has been served and applied. There is no reason why a solopreneur, engineer, right, who has gone through the motion and have applied himself and contributed to the community and the industry and the family and just about everywhere, going from respectable and basically well sought after subject matter expertise. I can command. I mean, I just said 2021 I was demanding $125,000 in salary, but now, well, I name my price. For my expertise and the consultation services that I provide, it all depends. But right now, with the court, it's there has to be truth and reconciliation, and I've been acting in good faith all along. So, from the epoch, in millisecond, each millisecond, right, is $100 million. Each millisecond is $100 million. In the previous recording on video evidence on the 24th of August, that was $1 million a minute. So you continue acting in bad faith, and therefore the punishment only increases. There are 100 milliseconds per minute, so $100 million. Because 1 millisecond is, once you have your heart zapped, all you have is a millisecond perhaps before you fry your heart, and you lose the ability to breathe, and you lose your life. So no amount of money will bring my life back had it been not for divine intervention. And I survived a taser attack. This is from before, so nothing. Still here, resilient. I have managed to develop thick skin, and both in the personal as well as professional and life circle. You have to set your boundaries and your jurisdiction and stand firm for your rights, and that are unalienable. Unequivocal right. Everybody has that unalienable natural rights and freedom, which are safeguarded by the Constitution. Exactly how they were managing, and they were able to actually enforce and basically have a unlawful court proceeding without my consent, because emergency act, well, the accuser is not there to defend himself. Well, guess what? Default judgment in your absence, because we have you in jail for no reason, without a just cause, despite the fact that I have informed you and alerted you that I do have a court appearance regarding a different matter in a different jurisdiction, that you have no reason to keep me here incarcerated without a just cause. Exactly how I got released on the 12th of December 2024, 9 days after in and out. This was my third time being released, and I have yet to receive my disclosure for otherwise 5 criminal charges, right? I know what they are. You told me it's mischief. Well, why mischief? Contesting unlawful seizure, unlawful arrest, right? Contesting unlawful and theft of my property without a due process and a court order and a search warrant and what have you. So mischief, obstruction, and 2 police assault, where I sustained, and I was tasered essentially as I called do the right thing, and as a law-abiding citizen, I do call 911, and Ontario Provincial Police is, I about to, go and seek help, distress call. Here I am being shot, tasered in Parkdale and Scott. So we have a record, and this is where I showed earlier the 5 criminal allegation before the court that they have fabricated evidence. Suddenly, I have a court case on the 25th of October 2025. But I don't consent. What happened to my court date tomorrow, the 25th of September 2025? I had been waiting since last year, 2024, August 24, and when I first got sworn in on the 25th of August 2024, the Crown Prosecutor received direction from another Crown Prosecutor in a different jurisdiction to keep me basically incarcerated for 30 days, the 25th of September 2024 through the 25th of September. Right, so 25th of August, 25th of August 2024, all the way to 25th of September 2024. Thereby, I would be missing my court date on the 10th of September 2024, Superior Court of Justice in Quebec, which was cancelled, and I was acquitted of the charges. I got the recording for the time being. I was being acquitted. I was being free. Little did I know that they basically were trying to conspire to, bust me elsewhere in Ottawa, and then, try to conspire and, be in complicit coordination between the two provinces, right, Quebec and Ontario. And I get to Alberta later on, as I had been taken into, Montfort psychic ward unlawfully, without my consent. Because the day prior to my release on the 12th of December 2024, on the 11th, I was requesting to be seen by a special hearing for bail hearing because, of my indigenous status. I speak perfect English, clearly. I can reason, I can think, I can respond, I understand the language, and not only that, I understand the laws and order and hierarchy, and you're not going to corner me into your nonsense, lower court's jurisdiction where I don't consent. I requesting public trial with a jury. I'm innocent until proven guilty. Fundamental justice. It's not rocketry. So, that's basically what had happened. And on the 12th of December, I was seen by Justice of the Peace, and she had seen me going back and forth. The first 2 times around, I was released with unlawful, unreasonable bail conditions, with my mother being my surety. I had told her to revoke the surety, and then my father later on threw me under the bus. Right, on the December the 1st, 2024. Why? Because he had, basically came to get me out of jail the very same day. On the 17th, I had gone to the courthouse to basically appear before my first court appearance on the 17th of September 2024. This is the first court appearance that, remember, they had me planned to stay. They had planned to keep me from the 25th of August 2024 to the 25th of September 2024. Now I was released on the 29th, with my mother first being my surety after 6 days going back and forth powerfully, and being coerced into signing unlawful bail release condition, which I did contest, and I have the record where basically I did not consent and sought, release bail variation. So, and I also elected that my matter be moved to the Superior Court of Justice before a public trial with a jury. It is not difficult. I've been going through the motion in a different jurisdiction called Quebec, and I have been going through the motion to be basically acquitted when my court appearance for the Superior Court of Justice in Quebec was cancelled on the 10th of September. So there we go. I remember vividly every single details and account, so I can talk to the cows come home clearly. So I'm overdue for this video, so just post it, and that's kind of a nutshell summary of the different allegations that I have, because now, when I was released on the 12th of December 2024, I was given a court date for the 25th of September 2025. That is tomorrow. Today is the 24th of September, right? So 2025. Tomorrow is supposed to be my court case. Why am I being pushed and delayed? So that's basically where I am, and there are concerns that I am not abiding by the unlawful bail conditions, which clearly, I don't consent to. Hence why I'm recording and uploading this, oral video testimony, so to speak, right? Video oral testimony, and you can see perfectly fine. Now, if you are advancing that I must go and seek some sort of because there's allegation again before me, right? They try to pull this trick out of a rabbit hat. Mental. What mental? I'm schooling you in your own game. What mental? Aerospace engineering, system design. I have zero record, criminal or driving at fault accident, nothing. I'm just a law-abiding citizen. I just happen to have gone through amicable divorce agreement and do not consent to the school board of basically injecting my daughter, or perhaps subjecting my daughter to unlawful therapy sessions that I have no idea what they are all about and the nature of these therapy sessions. Exercising my right as a father. Revoke my consent because there's a breach of trust between the father, right, and the school board with respect to my child daughter well-being and best interest. You ain't got nothing. No jurisdiction. Easy. So again, the ground of this application is very simple. Starting with natural laws, because we live on this planet, right? So we have universal laws. We go from A to B, anywhere on this planet, we're human. You got 2 hands and hopefully 2 eyes and a nice set of teeth and nose and ears and what have you, and 2 feet, and just a human being. So we live on the land. We're not fishes, so to speak. We don't live in the ocean or on the sea. So we live on the land, not in the sea. So corporate law, that is nothing but bylaws, corporate, maritime, commerce. So the operation of the vessel of this government under trust law. But when there's a breach of trust, contract void. So you have managed to seize my Canadian passport. I got the pictures. It has not been returned to the rightful owner, and it has been seized without my consent. So why? Same thing with other, perhaps, document and CD recording with respect to my court case. Again, I'll have to look through and see the record. And that's basically it. It's I get to go about life and business the very way like everybody else. I'm an entrepreneur. I have over 15 plus years experience. I've earned my experience. I've earned every single thing in my life. So now my house, which is the condo I had bought way back in 2007, is again a subject of another court case. So the motion is to combine all the court cases, which will be posted below with all the copies. And that's my video, because clearly you're not interested in speaking to me in a civil way. So now I have to try and get a hold of you. So I know your email address. So this will be a motion, injunction against all civil and criminal court cases, right? An injunction to all release bail conditions, basically, stop, cancel until we go through the court motion. I must be with full immunity. I must have full protection and immunity, right? Not, incarcerated in some sort of custody. No. Well, be at the, Days Inn in Brooks, Alberta, because I'm going to do work. And again, a man is his word. A man is his word. Put your word where your mouth is. I'm going to Alberta again with Brooks and, reconnect with my, newfound circle of friends and supporters, my tribe, so to speak. And I'll be going there to build my prototype. And as I mentioned, I'm building a device that generates electricity without the need for fossil fuel and no solar panels, and it runs 24 hours, 7 days, 364 days a year. Roughly it's $1,000 per 1 watt rated. So building 7.2 kilowatt system, that will cost me, with shipping and everything, $10,000. $10,000 and $100. So $100 is a security deposit. So basically now I claim the name as well as request and demand the transfer of the trust register in my trust account and SIM card right below to my legal estate. I'm the sole trustee and successor of that legal estate registered in my legal name. So Ahmad, right? Alpha, Henry, Michael, Alpha, Delta, last name Al, Alpha, Lambda, optional dash or no dash, what have you. That's basically where all this commotion has been happening. So Alpha, Lambda, last name, Sam, Henry, Elephant, Henry, Alpha, Beta Island, Al Shihabi. So again, the variation will be down. And SIM card, you already have it, no big deal. So that has to be all securely transferred with all liabilities and asset under my legal estate and my real estate, because I'm the title holder at the property in question, 3415 Uplands Drive, the old city of Gloucester South, Ottawa, Ontario, K1 Vector 993. I've got a private contract with the tenants that owe me over roughly now close to $10,000 in retroactive rent payment. So we have documentation, we can show everything, and the people remain living in my place. City of Ottawa can assume and fork the bill, invoice. I have no issue by housing my friends and people in need in my house, but again, if they can afford it, well, I don't mind if the City of Ottawa wants to have my property listed for community housing purposes, and I get paid. I got the title. I have a home equity line of credit. I don't have a mortgage agreement. So if I don't have a mortgage agreement, well, This would be bogus. This would be bogus because their primary ground is under the Mortgage Act RS 1990 CM40 S52 as amended. But guess what? I don't have any outstanding or signed contract agreement with the Canadian Imperial Bank of Commerce (CIBC) as of 2012 with respect to this property. Right? I had converted my mortgage to a full home equity line of credit at a valuation of $200,000 back in 2012. At the very same time, we were getting to get engaged and married, and purchasing our matrimonial home, which I coughed up the down payment alone. And over the course of 10 years of matrimonial marriage and relationship committed for over 14 years, well, guess what? I have the record. I volunteered 50%, which I don't have to, but it's okay. What is done is done. Not so that you go and now breach trust as the trusted mother of my sole child daughter, and for my sole child daughter not to be able to see her father and be deprived of her natural right as a child to be with her father, spend time with her father and the family. We're so happy. What just happened? What happened? We were just so happy. Suddenly, you're getting all worked up. For what reason? You have failed as a mother to look after and safeguard the well-being and protect your child's best interest. I was simply coming with valid concerns. You did not care, clearly. You did not receive the consent form that I received as the head of the house and the father. And guess what? She's my daughter, first and foremost. You want to walk away, you can walk away. You are more than happy to come and join us in Alberta and be, courtesy of the, courtesy of the government, right? Your counselor can be invoicing the government, because last I checked, I don't think you would have gone and, signed out a lawyer yourself. This is why I want to talk to you and see if you want to talk in good faith, and just make sure that you are not going to be subject of being the defendant. In this case, right now, you are being accused of breach of trust yourself, criminal negligence, corruption, complicit obstruction of justice with the legal system and the school board, and basically negligence towards the fundamental and unalienable natural rights and freedom for your child daughter. Right? You claim to be, she's our child daughter, but she's my sole child, so he carries my last name, Haneen Al-Shihabi. So guess what? That's what's up. Haneen will be reunited with her father. And again, I have a public proposal. I'm a man with multi-talents, with multitude of skill sets and potential to go about pursue life and happiness and live where I want to live in life. Well, guess what? Canada has just recognized the state of Palestine. Perhaps it's time for you to recognize the Palestinian people and accept us for who we are. I show nothing but love and compassion over a decade plus of a committed relationship. You don't want to be part of that, great. I don't force you. But you have to safeguard and protect what we had agreed on in what we call amicable divorce agreement. Not so that the stooges and the and the complicit, right? You're complicit with the school board and legal system, the corrupt that is, right? Just to go and modify otherwise amicable divorce agreement without my consent. When I was trying to pledge with you and try and go back to the same lawyer that mediator that you had chosen to go over our settlement and finalization before the court, and what changed? I don't tell you what to do. I don't force you anything. I never force anything on you. In fact, I strained my relationship with my closest people to me, my family and my close friends, because I stood your ground no matter what. You are in my care, my custody. I defend you no matter what, right or wrong. I'll try to reason with you when you're wrong, but I can't force you to see it my way. But you'll have to accept my assessment. But at no time I made you feel that. Well, if anything, you're in breach of trust. I have a mother that you not once agreed that she would live with us. Why? I can't force you, that's fine, but this is my culture, my belief, who I am as a man. I'm taking care of my mother right now. She is 68 years of age. does not need to be going back and forth into courthouse because of your ignorance of the law yourself. Section 19 RSC 1985 CC 46. Again, I implore you, you're an intelligent person. Perhaps you had gone to university, we met, right? English, right? Minor and history major. Well, remember where you come from. I know where I'm from. Proud indigenous Palestinian, born refugee. That's right. Now we have the state of Palestine. Well, guess what? I proudly wear my colors. I always did. I never forgot. I came here for a better life and happiness. I happened to fall in love. Both of us, we happened to fall in love. There was nothing you could, no force in this world could, basically, no force, no power could have forced us apart. But you, on the other hand, walked away. I can't force you to stay with me. The same thing, I can't force you to leave or be with me. It's your choice. That's life. You have your own wheel, I have my own wheel. Remember, one day you're here, and the wheel goes down, you're at the bottom. You just have to be true to yourself. So, it wasn't my intent to basically go after you and get you involved, but since that you involved my daughter and you put her in the crossfire for something that we could have just simply resolved privately, but you chose to involve the legal system when we had amicable divorce agreement. So now you have to harvest, re-up your own kind of what you planted, the seed of evil that you had no reason to go after, and in a failed attempt to defame and character assassinate perhaps your man. What exactly did I do to you? What exactly do I have that you are not happy with? You're not happy with me, you left, so be it. Oh. So, you gotta look in the mirror. The only person you lie is you're lying to yourself. At least my daughter, whatever happens with me. My daughter will grow, and she will get to hear and see and understand the truth and hear her father talking, because there was no reason for my child daughter to be separated and deprived from her through one and only natural dad and biological father. Right? She's daddy's girl, best friends. So, and yeah, that's all I have to say for the time being. So I hope it's clear what grounds of the application is warranted under the natural laws, universal laws, natural laws. You don't have to go universe too much because we're still here. You don't have to think universe, right? Just think natural laws for now. You're a living human being. You have unalienable natural rights and freedom, which is part 1 of the Constitution or the Charter, right? And that is safeguarded and protected by no other than the supreme law of the land. That's why it's called supremacy clause, section 52, subpart 1, part VII of the Constitution Act 1982. And that is any child law, at a municipal or provincial level that goes against or in contrary to the Constitution, being the supreme law of the land, is to the effect of no force. It's null and void, so to speak. So I do not consent. And this is why the primary premise and ground of this counter claim and lawsuit versus party B, you, the accused. No, you're the defendant. You're not accused of malintent, but you are accused breach of trust, and that's the least I can throw at you. But you can live with your own kind of guilt, if you will, if you have one, that is. Because again, I'm here, and as I offer basically a true peaceful reconciliation. I mean, with you I have nothing against you, but if you have something against me, well, we have to set the record straight before you go about and request things that it does not make any sense, and I have to agree to unlawful bail release condition that again is not justifiable without a just cause. So you're dealing with the consequences for your bad faith. So good faith and bad faith. I come in good faith, I lived in good faith, and I leave in good faith. True, always. I wear my heart on my sleeve. I have nothing to hide. I'm speaking. Perhaps too much for your liking, but hey, What are you gonna tell your daughter? That's fine. I'll tell my daughter to love her mother, no matter what. I don't take ignorance of the law, because blissful ignorance can be pardoned, but willful ignorance. And again, I won't stop until I get my court case date set before the Supreme Court of Canada within 48 hours once my application has been received. I mean, I've been going at it, right? Anyways, I have to help my mother. Sure. Anyways, I'll see you next time. So remember, the executive orders, injunction, right? Basically, suspend all charges, stay down all the charges, both civil and criminal, right? I must be reunited with my daughter, right? Safeguard measures. I want to have a safe and basically secure passage, right? I would love to rent a car again and drive myself. I have no issue with that. Now he suspended my driver license indefinitely without a just cause, right? Which resulted in the impounding of my vehicle in Alberta, a car rental in Ottawa, impounding in Alberta. But suddenly I have a search warrant. Why? I don't have a search warrant. When I left Ottawa on the 14th of January, or the 16th of January, I should say. 14th is when I got the rental. On the 16th, essentially, I had gone and I left Ottawa on my way to Alberta, and I've been recording. I have all the record about giving my story and giving my live update, right? Wellness update. Because, safeguard and protect, make sure that this man is not going to, hurt himself or others around him, which is the straw man argument that they have been using. Primary ground, secondary ground, tertiary ground. They have to go through that because the primary ground, secondary ground has been thrown out of the court the third time around I was released. Right? Primary ground, similar allegation. Well, they have been acquitted. Secondary ground, public safety risk. Well, does not fit that profile. And third, basically, I forgot which one, but I'm gonna hurt myself or some shit. Mental. They are now bringing this, basically pulling this trick out of a rabbit hat. And remember, the onus is on the alleging party. But again, so if I'm mental, according to you, NCR, that would be falling under non-criminally responsible, so I shouldn't be in jail in the first place. So again, you don't make any sense with any of your fuckery, as I call it. So now, guess what? We're going before Supreme Court of Canada. I do not consent. I can only go to a doctor once I consent. The doctor of my choice, at the place of my choice. We'll go to Alberta, do business. From there, whatever life takes me. We can continue to do this back and forth and, live meeting. And again, it's public trial with the jury. There's nothing we can protect the identity of the people that needs to be protected. But at the end of the day, I'm claiming my name and my sole child daughter and my immediate family, starting with my mother, my sister. Optional, because she has a choice. So is my mother. My child doesn't have a choice but to be with her father when her father claims her name. It's that simple. And my ex-wife, so to speak, she's more than happy to be part of that trusted tribe. Otherwise, well, she can go on with her life and cut her losses, because that's it. You fool me once, good for you. You fool me twice, well, it's a different story. So I have been peaceful, but don't mistake my kindness for weakness. I'm not weak. I know exactly what I'm doing. But those who do not understand basic hierarchy, laws and order, well, that's why you stay in jail and you stay in remand, and you're at the mercy of the crooked and corrupt judiciary system, which has been long compromised. So it's nothing to do with AJ case particular, but it has to do with the fact that it is systemic. It just so happened that AJ understand basic rules, laws and hierarchy. So therefore, with the experience and the knowledge, the law is very simple to understand. The application of law is where it becomes convoluted, and that's why you have to go seek different lawyers for different things. Criminal lawyer, 10 years experience, then you become assigned as a judge before being appointed by a senior judge, right? You're pushing 40 minimum, so you gotta look at least like me, or older. You can't look younger. It doesn't make any sense. So yeah, that's basically where I am, and we'll end it here. And yeah, that's it for now. Tomorrow will be the application, so this is kind of the perhaps extended executive order. So I'll be shooting a smaller 5-minute video just as a summary, executive order and the grounds of this application, so I can satisfy the requirements. Doesn't have to be in type format. Well, you have now audio. You can go back, and I will write down again under a blog entry. So you say we received, we saw the video. Well, it's public record. It's on YouTube. It's not like you need some sort of a secure link to access it. It's public. I'm speaking about my personal life matter, including the court and corrupt judiciary system here in Canada, the land of free. Salam, to be continued.